Hi, I'm Greg McIntyre, and welcome to this week's edition of the Elder Law Report. Today, I wanted to tackle a topic that is tough for some of us, and it's confronting the end of life issues. The fact that we are all going to pass away one day. That's not something that I like to think about in any way. That's not something that is easy to talk about for most of us. And because that is an issue that we want to avoid as human beings, many times we put off planning for that issue. And one way to have more peace of mind and to really take the fear out of a lot of those things is to confront them, to confront our fears, to accept that we are not going to live forever on this earth, and that we need to take care of ourselves while we're alive. We don't know what's going to happen with our health care as we age. Statistically, there's more of a chance that we're going to have ailments, physical ailments, accidents that could lead to long-term care, or with the rise and the drastic rise as we live longer and longer of what we call dementia, maybe used to be called senility, and maybe subsets of dementia like Alzheimer's. And, those are pervasive diagnoses that are given out all the time right now. And that puts someone in a tough position when it comes to managing their own financial or healthcare affairs. So to be proactive and to plan ahead, here's what I counsel many of my clients on. In those situations, we want to make sure those clients have in place, if they have people in their lives that they really fully trust, general durable powers of attorney, where they appoint an agent to handle their financial and legal affairs if they can't do it themselves. Also, healthcare power of attorneys, so that they appoint the person that's the right person in their life to make healthcare decisions for them. To pull medical records, we'd need a HIPAA authorization built in that healthcare power of attorney, maybe even to handle burial and funeral and limit how that's handled, but to appoint an agent to make those important decisions for us. Those are two elements of planning ahead that can help you avoid guardianship. And those are court proceedings where someone is petitioning the court to find you incompetent and then appoint a guardian to help you make decisions for you under court rules and court oversight. Guardianship is something I recommend sometimes, depending on the situation. If someone is not capable or has waited too late to try to put in place a general durable power of attorney or healthcare power of attorney and just aren't competent, they're not capable of making their own decisions and of signing those legal documents and contracts. So planning ahead always works best. But first, we just have to realize that we are not invincible. We have to face reality, the lay of the land, and face that we are all going to pass away one day. So then what do we want to do with our assets? Well, I think that we want to really, and part of the crux of my practice is that we keep people in charge of and in control of their assets while also looking to protect their assets, not give away their property, not lose their property because of a long-term care situation. So we can accomplish that by either using trust, or we can accomplish that using just deed protection on the property. It depends on the situation. There's not a one-size-fits-all for everyone. It depends on your goals, your asset makeup, your health, your family situation, right? Whether you're married or not, how many kids you have, if so, how many, right? How many people do you want to include to receive assets, and how we're passing assets. Now, the dangers sometimes of just using a will are that if you have a long-term care stay, then you may be in a situation where Medicaid has to come in and pay for that stay. And in that situation, if Medicaid comes in and pays for a long-term care stay, then they're going to attach a lien on your probate estate, which is the process by which a will passes property. Okay? So they're attaching a lien there that could take the house, okay, to pay for that claim. And there are ways that our benefits programs, along with the state of North Carolina, have provided for you to keep your home, stay in control of your home, pass it outside of probate. That might be a ladybird deed. It might be an irrevocable trust where the trustee has a legal fiduciary duty to maintain your assets, even retirement investments or invested money for your use and benefit for the rest of your life, where you're a lifetime income beneficiary. You live in your home also, and then it's protected and treated as a separate asset if you have to go to long-term care and qualify a benefit like long-term care Medicaid to pay for nursing home care. So those are the type of planning tools that I as an elder law attorney at McIntyre Elder Law provide and have provided for a long time. And we keep learning and growing just like you do and getting better at what we do and what we can advise our clients to do. So I want us to all realize where we are and do whatever we need to do to be okay with the fact that we are mortal and we are going to pass away one day and we may have health problems, and that 70% of seniors are going to need some type of long-term care during their life, and that's not cheap. I would offer a free consult to sit down with you and your family to put a plan in place that's right for you, to help you stay in control of assets while protecting assets and still leaving the third thing, availability to qualify for benefits to pay for long-term care. You can schedule that free consult by going to mcelderlaw.com, or you can call us at 1-888-999-6600. Thank you and have a great day, and stay tuned for next week's Elder Law Report.